Yeah, right. Here we go. Okay, here we go. Okay, do. What am I doing today? I don't even know anymore. Okay, there it is. Sorry, everyone. Hello, hello. Trying to get myself sorted out as per usual. Good morning, or good afternoon, or evening. Welcome in, everybody. Welcome, welcome. Got one more little set here that I need to finish. Oh dear, where did I put that? I don't know why I'm a little extra forgetful these days. I blame my husband because it's got to be his fault, right? Everything is his fault. Oh, hello, Jelly Kelly. Of course, of course. I do have scheduled to try to get everything posted up to the tube of you as quickly as possible, but it's been kind of a crazy week. So, hello, Upgrade 2.0. Good to see you always. Hello, El Jenny. Yes. Oh my gosh, we got so much stuff going on. I tell you, it's too much. It's too much. I want to just be like, listen, it's okay. Good afternoon, Kaya. Hello, hello, hello. Always working so hard out there for us. All right, I'm trying to pick a ring. One last ring. Oh, here it is. I don't know. Do purple and pink clash? Oh, I feel like someone told me that once, but I'm not sure. Yeah, I'm not sure. Will it ever stop? Well, someday. Right. How to lose your law license in 72 hours? Yes. Yes, it's not looking good. It's not looking good. Now, real quick again, I'm just getting everything set up, everybody, but and I think I talked about this yesterday or the day before. I can't remember the last live I was. I think it was the day before. We can learn it. We know where to find the information. We can teach ourselves, but some people just don't know they need to do that. Some people just try to, say, well, whatever I do is okay and I'm going to get away with it. And then they get frustrated because, things happen to us. That's unfortunate, but there's a lot of that. Honestly, in my opinion, it's an entitlement issue. I'm not sure I've seen people who have actually worked hard to become attorneys with that much, I guess, stupidity to just go cold turkey into a hearing you don't know anything about other than your, propaganda. Like, I don't recommend that. I would, don't do that. If that's you, don't do that because that's not good. Hubris. Oh my gosh, of course. All right. Sorry, everyone. Here, I'm trying to get my last ring on here. I thought I already had a ring. No, I took it off. Okay. Scattered all over the place today. My goodness. All right. Oh, it's over here. Nope, is it? Okay. Oh my gosh. Wondering about Bondi losing her license, actually. It could happen, actually. Sorry, getting my ring. It actually could very well happen. She is way outside of what's appropriate for ethics. Already the American Bar Association has filed a complaint already, being like, dude, this isn't right. And then the rest of us are just kind of waiting patiently because, she's out of Florida and they're like, well, in Florida, we're not going to do anything until you're out of office. Like, okay, that's fine, but absolutely possible. All right, everyone. I'm sorry. I'm so sorry. And I've got my big flower ring out here. All right. Is that too distracting? Let me know. But I'm I'm still struggling here a little bit. Bedazzled, that's right. Love that. Where can you watch the trial live? It's not going to be live. It's this isn't going to be a. Oh, good. Thanks, Bruce Wayne's mother. I appreciate it. Hope Bruce Wayne is being nice and not naughty. But yes, so these kinds of cases, they're a bit rough, Chris. They're a bit rough, but they do not allow, cameras in the room. So some states may allow it, but then some may not allow it for different cases. So, really? Oh, love it, love it. So, right, for now he's napping. Well, it seems like it. So, just a heads up, everyone who may be new or not familiar here. I do have a couple of health problems, and one of them is tremors in my hands, and so it's getting a bit progressively worse, and so I need to kind of have compression things, and then which are not very attractive. So then I just kind of put a little wrist warmer on over it. All right. So usually I'm wearing just, a regular shirt, but these last few lives, I've just needed to have a little bit more. So if you see any shaking, no worries. Don't feel bad. There's no pain. It's just kind of how it is. Oh, good. Thanks, Mary. I appreciate that. Yes, the wrist warmer. I know, right? I know it. All right, so anyway, just, it's fine. It's fine. I'm fine. It's just a flesh wound. Just kidding. It's just fine. Here we go, everyone. Let's dive in. We got so much going on right now. So the first thing, this is the only sketch I've really seen of this. I'm going to forget her name. I forget her name every time. What's her name again? Hold on. It's coming to me. Nope. Yes. Who's got her name? Is it Halligan? Halligan. Oh my gosh. Doughboy. Yes. That's what I thought. I thought it was Halligan, but I'm like, I was saying it wrong. Okay, so Lindsay Halligan. Let's just kind of put this up here so I don't forget. Let's say. Oh, good. I'm glad. I'm glad. Bruce Wayne's like amazing. So if they're having a good day, that's great. We love that. Houlihan. No. Oh man, that was a great show. Did anybody ever watch MASH? It was a great show. This is all right. Let's backtrack. We've got two cases going where this lady here is like, okay, I have no experience, but I will try these huge cases. These enormous cases, I will go ahead and just try them. One, of course, is Comey, and I do have that. I will do another live on Comey because we've got some really interesting twists and turns. But we do have the second case here. This is District Attorney Attorney General Leticia James. She is right. So the Leticia, oh my gosh, everybody, you kind of all know the story. She worked very, very hard as the Attorney General and brought, as is her job as the Attorney General, brought some filings into court for Mr. Orange. He and his attorneys just badmouthed her the entire time, said some really, really horrible things, and tried multiple times to have her recused or taken from the case, the judge taken off of the case. This is the case where Judge Engoron was involved, and he was talking about your penthouse isn't 50,000 whatever square feet or whatever, it's 10. So this was where we had some fraud issues. I mean, I know that's all of his cases, but this one was his business, and there was a huge award amount that we all knew. It was like was it $500 million? That sounds about right. We've all got to do our best. True story. True. Yeah, so this huge amount of money that Judge Engoron had said, this is how much your bad behavior benefited you, and so blah, blah, blah. So that's the thing. When she was on that case as the Attorney General, she brought the case, and man, they were so mad. Oh my gosh, there were different restraining orders put out for extrajudicial comments because he would come out and say all these really, really awful things and such. So we had to have, we had to have some kind of a structure put into place. All right. Well, that's a bummer, Kathleen. So let's move here into the case. Let's move forward. I'm going to take you real quick through the docket to see what's been going on in this case. Comey's getting the highest coverage, but they're hand in hand. I mean, these are hand in hand. He did Dolores. This gets away with saying such horrible things, but anybody else do it? And oh, I know. You know, Honolulu girl, I tell you what, I don't know why he is such a, slippery fella. But if anyone figures out why, you let me know. I have a hunch that it's because he's got blackmail material on people. But that's it. Can he call witnesses to the stand? If you're talking about Comey, hello, Dolphin. Comey is represented, and so they can bring in whomever they want. So here we go. Let's dive in. Oh, sorry, everybody. All right. Originally, I did go through this indictment when it first came out, and I am going to, let me finish my sticky note here so that I'll be able to leave it at the side where no one can see it. But yeah, it still has accurate information on it. All right, so I'll take you through the docket real quick, show you where this case is at right now. And then we also have a motion to dismiss that has been filed by AG James. And so we're going to need to be looking at that because she's like, no. We're not going to do this. So maybe it has an error. I wouldn't be surprised. All right, here we go. Wait, which one? I gotta pick. I promised I'd pick a different wand today. Oh, here we go. This one's pretty. All right, next wand. Here we go. So October 9th, we had the indictment. The indictments, to just refresh your memory, had to do with alleging that false information was given regarding property that she purchased in another area and like what the property's purpose was and such. All of us that have looked at it have said, I'm not sure here that any of this fits with what you're trying to charge, but there you go. Oh, thank you so much. Yes. So these two go hand in hand. All right. Now we have separate dockets running for them, right? But they're hand in hand. So they're just like, like co-cases. They're talking to each other about it. So again, here's the indictment. It came out, some false information. It's pretty petty. And actually, I think some of that's what, Orange was charged with. Next, here's the summons on October 9th, the notice of attorney's appearance here. So we have Bose is representing Miss James. Then here we have a motion to appear pro hoc vice. Now, pro hoc vice, just to remind everybody, just means you're licensed somewhere else and you'd like to come in and work this case, but, just this case. So you're kind of granted I don't want to use the word visa anymore because who knows what that means, but you're granted a little period of time where you're able to practice in front of the court. So motion to appear pro hoc vice is another one over here. And another pro hoc vice, and then we've got another order setting out all of the people with the pro hoc vices can come in, and that's fine. Oh, I don't think I set, oh my gosh, everyone, I don't think I even set a gift goal today. So, sorry about that. I think last time, what did we do last time? Oh, we had the bubbles. That was so fun. Oh my gosh. Squirrels, everybody. Next up, we have an order granting a motion for pro hoc vice with James here too. So we've got 6 here, and then we've got 7 here, and then another one granting number 8 here. So just a lot of attorneys coming in. And here we have an order on the arraignment of AG James, and beginning promptly at 11 a.m. An arraignment is when you come in and you say like, well, what's going on? Initial appearance, everyone's guaranteed to have that, so we don't have a habeas corpus. There's one up there. Oh no. No, what do you mean? Another one? Right. All right. So, I'll have to pick his word. Oh, you're so sweet, Chico. I appreciate that. All right, here we are. Back to the arraignment. You choose, guilty, not guilty, or in some places you can plead what we call a nolo contendere, which means no contest. And this was actually one of Mr. Orange's father's bits that he did when he got tangled up in the law. We'll call him like, grapefruit, I guess. I mean, I don't know. So Mr. Grapefruit and Orange got into quite a bit of trouble back in the 80s. And even before that, I think the first one was in the 70s, come to think of it. The reason I bring this up is to say a nolo contendere plea means I know there's evidence out there against me. And, I get it. But I'm going to say I did not do it, but go ahead and take that conviction. All right? So that's kind of how we're dealing with nolo contendere cases. Some states allow this in certain situations. Others require certain kinds of paperwork and stuff. I'm going to spell it wrong. Contendere. Nope, that's not. Latin. Nolo contend. All right, well, there you go. Sounded out. Melonhead. Is that right? Okay. I can't think of it, everybody, for some reason. I apologize. All right, so there it is. We got that. The third one, like, fine, you can convict me, but I didn't do it. I will never admit to doing it. That's the piece. Contendere. Thanks, Steffi. Oh, my gosh. Steffi. Thank you so much. Contendere. Oh, my gosh. Thank you, everybody, that helped me with that. Yes, the Alford plea, Bri, is also a piece of that as well. The Alford plea is, of course, later on down the road. That's why, we refer to it that way, because the nolo contendere happens at the very, very beginning. So one is like your position going forward on a case. The other is a plea negotiated where you're not admitting guilt and you're making an agreement with other people. So basically the same thing, just the timing's different. So we had here her arraignment, which, by the way, as a quick side note for everyone, nolo contendere. Yeah, I used to, all right, I've always struggled pronouncing words correctly, but the Alford plea was when, oh my gosh, I was a green prosecutor, everybody. And I was like, all right, let's do this. We're going to work together. I was working with, opposing counsel and stuff. We were putting a plea together. And he's like, well, what about an Alford plea? And I said, you said Alford? It's Alfred. Everybody knows that. And I was like, so full of myself to this other attorney. Like, everybody knows that. I mean, why would you say it incorrectly? And to his credit, he said nothing. And then later it was like, oops, I was wrong. Yeah, but anyway, sometimes that happens, people. Next, October 17th, we've got a summons, pretrial report here, notice of attorney's appearance for the U.S. here, corrections that needed to be made, more notices here for coming in, notice of intent. Now, you might say, why are we filing notices and then filing the documents? Because quite frankly, we may not be done. We may not be done with our full-fledged complaint issue that we want to raise. We may be still, in the weeds of it, but we want to preserve the place. We want to preserve the fact that we're having it. So we're like, hey, we're not going to file it right now, but we do have it. So, this is the step that goes before. So notice of intent to file unlawful appointment by Ms. James here. So unlawful appointment first, and then we have a motion to enforce rules prohibiting the government's extrajudicial disclosures and statements by Ms. James. So, oh my gosh, here's another situation where they are saying, you're saying a whole bunch of crap outside of court, and you can't keep doing that. So, we're going to follow this motion. You need to follow the rules, dude. Keeping them in check again. Like, that's funny. Yeah, I don't know. Sometimes I just, words are hard sometimes. So up next, we've got a motion to dismiss the indictment. That's the big one here that we're looking at up here. So motion to dismiss the indictment and join the prosecution. That means stopping the prosecution of Miss James. So that was filed on the 24th of October. There was another order on a motion to dismiss, right? Here, the motion's transferred to the Honorable Cameron McGowan Curry. So with that request, basically, to, start working at this dismissal level, they made sure they wanted to give it to a judge straight up so they'd have time to go through it. A senior United States District Judge. Good job. Next, we have the order from the chief judge. Ooh, all right. So here, let's look and see what this one is. Minute entry, initial appearance, and arraignment. And a lot of times you can do both of those together. As to Leticia A. James, held before District Judge Jamar K. Walker. I have a hard time with the L's. Government appeared through Roger Keller, Lindsay Halligan. So this is the cray-cray situation. This is Miss Halligan, who's in some trouble, and Amanda Cheney. Defendants present appeared through attorneys here. We've got Lowell, Bossy, or Kolansky, and Oishi. I hope I'm saying that. Oishi. Thank you so much, Paco Taco. All right, well, I apologize, Miss Oishi. So there are the attorneys for her. She waived a formal arraignment, which can happen, entered a plea of not guilty, demanded trial by jury. So look at that. She made sure to check the box. If you know, you know. Oral admonition as required by DPPA given to the prosecutor. Briefing schedule set as stated on the record. Any motion to dismiss based on the appointment, qualification, or disqualification of the United States Attorney or United States Attorney's Office to be transferred to the Honorable Cameron McGowan Curry. Hearing on any motion to dismiss based on a theory of vindictive and or selective prosecution, so those are the criminal pieces there, set for December 5th at 11 a.m. Hearing on any other pretrial motions set for December 17th. Here, jury trial set for, and let's make sure we highlight this, January 26th. That's when her trial's to begin. And then where to meet people. Well, you know what I'm saying. You know, if you know, you know. Next up, Due Process Protections Act order. As to Miss James here, so there's an order that they put in. Again, we've got the jury trial shall begin on January 26th. A joint proposed discovery order is due by October 31st. On a proposal plan by November 3rd, government shall file a response to ECF 21, which was her motion to dismiss, by 10/28/25. Defendant's replies due by 10/30/25. And then additional deadlines are in her filing there. All right, so that really takes us then to more up to date. So here we go. We're going to start moving a little faster here. So we've got an order here. Government's response on defendant's motion to dismiss here is due by 5 o'clock. So they're even not turning their stuff in on time. Motion to dismiss hearing here. An order setting conditions of release for Miss James, which, excuse me, is normal. An order here, the government is directed to submit no later than November 3rd for an in-camera review all documents related to the indictment signer's participation in the grand jury proceedings, along with complete grand jury transcripts to be delivered to chambers of Judge Cameron McGowan Curry. Sorry, everybody, it's our cocoa time. All right, so she said, or the judge was like, you need to do some stuff. Transcripts were sent out, response and opposition by the government here. All right, fast forward. Proposed discovery schedule, agreed discovery, motion for excessive pages. That happens a lot in big cases. Then the judge is like, fine, you can do that. We're granting that excess pages. Also adding another attorney in here. And then amended motion to appear here for this person, and so on. And then an order on defendants' motion to enforce rules prohibiting the government's extrajudicial disclosures and statements is granted. So when she said, look, can you tell him that he needs to follow the rules? And the judge is like, all right, here you go. And then that's been set out. So notice, response, consent. Let me like to see that. Consent motion to continue December 17th hearing for additional pretrial motions. So they moved that date down further. All right. And again, we're just kind of skipping here. Government's filing regarding discovery here. Notice of attorney here. Unopposed motion for leave to file a brief of bipartisan former federal judges and former U.S. attorneys as amici or amicus curiae in support of defendants' request for relief. So she's got this whole group together. Well, she doesn't, but they did. They're like, look, we got some stuff to say. Financial interest disclosure statements. Another motion to dismiss the indictment for vindictive and selective prosecution brought by Ms. James. So now we've got two motions to dismiss on the floor. All right. And then we've got, of course, the exhibits. Most of the stuff is available to the public, but some of it has been kept from the public. So we don't really know everything that's going on. Right. All right. Motions for leave to file amicus is allowed. We've got a bipartisan form of federal judges here. Then we've got a reply to the motion to dismiss from Ms. James, and then the motion on behalf of the former senior officials of the Department of Justice. Whoa, we've got another batch of, extensive career attorneys here. Two amicus briefs, and they're probably really long because we're all a little bit long-winded in this profession. All right, pro hoc vice, attorney appearance, notice of waiver of hearing, notice of attorney appearance again, motion for leave to file amicus, yes, it was granted. Pro hoc vice, yes, it was also granted. And notice, and then an order granting motion for leave to file as to Ms. James, number 1, for good cause shown. The motion for leave to file an amicus brief is granted. So again, we're going in and collecting all of the information here. And notice of attorneys, blah, blah, blah. And then more notice of attorneys here, blah, blah, blah. Motion to appear pro hoc vice. These are all amicus or pro hoc vice questions at this point. So we're not finding any orders that have a lot of substance to them. Each one of these is saying yes to each one of the people asking for pro hoc vice or for amicus briefs too. So all of these as well, a brief of 58 bipartisan former state. Whoa, this is the third one that's this huge. A brief of 58 bipartisan former state attorneys general as amicus curiae in support of Ms. James. Yikes. That's a lot, everybody. Let me bump back up here. Let's see if the United States has anything that anybody amici-ing for them. Brief of amicus curiae for the United States, Senate Minority Leader Charles Schumer and United States House of Representatives Minority Leader Hakeem Jeffries. So I guess they're filing something. I'm not sure. I'm not sure what their stance is, but all right, whatever. And again, more of those until we get to a couple of days ago. So we're still kind of going through the process of getting the technical stuff that we need in order to go forward on trial. So then, everyone, let's take a look then at A.G. James's motion for dismissal. And, you know, I mean, she's an incredible attorney, and her filings are very well done as well. But yeah, let's take a look and see. I mean, I think we all have a pretty good idea of what the government is saying, right? That, you know, this is super, super duper important, so it can't be dismissed. That's kind of what they're saying. Right. Oh my gosh, Upgrade. I tell you, oh my gosh, they're just, sometimes I forget like how many attorneys are in this country, because I'm just seeing like hundreds and hundreds of them, you know, filing for support against constitutional breakage. There's a lot out there. Alberto Gonzalez. I'm not sure. Is Alberto the one that we had isn't he pro se? Was that, if I remember him correctly? He was on another amicus brief road not too long ago. All the names blend together. All right, I'll just put it to you that way. Let's take a look here at this motion to dismiss, everybody. It was filed 11/17. So Attorney General Leticia James motion to dismiss the indictment for outrageous government conduct. That's huge. Now, usually, for those of us in the field, we will say, yeah, what? Because the defendant's like, oh, they're being so mean to me. They're such jerks about it. It's like, well, that's not actually outrageous conduct. That's just conduct. But when we're in this kind of a situation and we're reading through this, it's like, that's outrageous. That's a lot. Oh, under Bush. Yeah, I don't know. But if he could be qualified. He may have a special way of looking at the cases. So Attorney General Ms. James, by and through the undersigned counsel, moves this court to dismiss the government's indictment pursuant to Federal Rule of Criminal Procedure 12B. As explained further below, multiple government actors engaged in outrageous conduct to obtain the indictment in violation of the Due Process Clause of the Fifth Amendment. Because this prosecution is patently unconstitutional, this court should dismiss the indictment with prejudice. Of course, with prejudice means you may not bring it again. Here's our table of contents. We've got our introduction, our background, transforming the FHFA into a political weapon. Oh, man, the weapons, I tell you, people. B, outrageous government conduct at the Department of Justice. Yeah, we got a lot of that going on. Ed Martin's outrageous conduct. Lindsay Halligan, whose only credential is loyalty. Wow, they didn't even... All right. Hold on there, everybody. Is installed as U.S. attorneys. It has no credibility, except for saying, like, I'll do whatever you want. Oh, I love it. All right. C, after ignoring the evidence and removing resistance, an indictment is returned. Yikes. Argument. So here's our arguments. She said in the background up here, and this is what they're choosing to fight about. The indictment against A.G. James should be dismissed because this prosecution arises from outrageous government conduct. And I agree completely with that. This court should exercise its supervisory powers to dismiss the indictment. C, in the alternative, Attorney General James is entitled to discovery to further demonstrate the illegal basis for the charges against her. So discovery, of course, is that period of time when you can ask a certain number of interrogatories, you can get depositions, you can request paperwork, documentation, those kinds of things. Here are our cases that she is working with, and then our statutes here. And let's just dive in, everybody, because this is just I'm sure. Well, I cried after reading this. You know, that's the thing, though, Punky the Cat. I tell you what, if she really, and I know I've been telling everybody what lately. I tell you what, if she, I'm sure she's stressed out because she doesn't know what she's doing, but you know, I have some empathy for that. But the other side of it is, you know, both Miss James and Mr. Coney, they are attorneys and they have so many years of experience. So for them, they knew exactly what violation she was doing. So they're going to toss those at her. But what would have happened? What would have happened if she had gone into court against another just plain vanilla attorney who's like, what? Why don't you know this stuff? There's so much damage that has been done because of her lack of competency and in the future. So, I mean, is she going to get all the cases now in this particular area? So case after case after case, we're going to be dealing with the same level of incompetence. So that's pretty bad. Also weaponizes tears. Oh, yeah, right. Oh, I know. This is when we've, is the tea hot? I'll double check here. This is, you know, before this whole situation with Mr. Orange, all right, back in the day, we didn't have all this crap that we have to deal with now. That's not very nice. Let me rephrase that. We didn't have a lot of social media. We didn't have a lot of things that showed exactly us doing the crime. So now we've got like newspapers, magazines, whatever that is, and then all these social media posts. Like this was never part of our system until now. In fact, it was very controversial because people wanted to use it, but then they're like, well, somebody else could have written it, blah, blah, blah. So basically back in the pioneer days, apparently, we didn't use social media. Here we go. Introduction. Ms. James has already moved to dismiss this indictment in response to the improper procedure and motives that led to its return. This motion seeks dismissal of the independent ground that this indictment is a result of outrageous government conduct, starting with that of Federal Housing Finance Agency, so FHFA, Director William Pulte in violation of A.G. James's due process rights. Outrageous government conduct prohibited by the due process clause is conduct that is shocking or offensive to traditional notions of fundamental fairness. I wonder if she put the stomach pumping case in. Nope, doesn't look like it. Well, maybe it was. I digress. Perhaps in no case before this court has there been a more shocking course of government conduct. The unprecedented, extensive, and outrageous misconduct in this case reached its apex when President Orange, as part of his revenge campaign, decided that A.G. James needed to be indicted no matter the cost. Years of relentlessly calling A.G. James a crook and a criminal reached out a crescendo when Mr. Orange posted on Truth Social the following excerpt here, all right? I'm just going to say that this is a post and it's not, it's opinion here, all right? These aren't facts. These are opinions. Here. Oh, I bet. Oh my gosh, Dolores, can you imagine? I don't know. I'd have to be like, I can't represent you anymore. And then they would like have a video of me that they posted, right? It would drive me crazy. All right, Donald Trump here. Pam, I've reviewed over 30 statements and posts, saying that essentially same old story as last time. All talk, no action. Nothing's being done. What about Comey, Adam Shifty Schiff, Leticia? They're all guilty as hell. What? But nothing is going to be done. Then we almost put in a Democrat-supported U.S. attorney in Virginia with a really bad Republican past. What? Like, people go for the job. They don't go to, scratch off names off of a list. Only weird people do that, all right? The rest of us are like, we got work to do here. A woke a rhino who was never going to do his job. That's why two of the worst Dem senators pushed him so hard. He even lied to the media and said he quit and that we had no cause. No, I fired him, and there's a great cause, and many lawyers and legal pundits say so. All right. Lindsay Halligan is a really good lawyer and likes you a lot. All right, because that somehow matters. We can't delay any longer. It's unaliving our reputation and credibility. They impeached me twice and indicted me 5 times over nothing. Justice must be served now. Signed, Mr. Orange. So a couple of things to take a look at here. There's a lot. There really is a lot. But he's talking about the reputation and credibility. And to that, I would argue there's none left. So there's none left to be damaged. So if they're trying to come in and say, well, you're going to hurt my reputation, it's like, that's not going to be a winning point for you. Right. Oh, thanks, V. Yeah, no, these are some of my faves. Gotta have some fun nail situations going on over here. Keep it exciting. All right. This indictment is the product of months of illegal and unethical behavior by government officials, only made possible by the misuse of a federal agency. Sorry, everybody's got a legend over here. Just a moment. Nope, not that one. Yikes. Oh, wait. No. And where did I put it? I put it over here. Oh, I did. Okay, good for me. Sometimes I forget. Oh, thanks, Thomas. Yeah, we've kind of entered my next era. I'm hoping. I go in and I do PT a couple times a week, and I just started doing that, and I think that's going to be great. I think it's going to have some great results. So I'm really excited about that. Although my therapist was like, my physical therapist, right? My PT person, she's like, can you bring it down a little bit? You're just a little too excited. I'm like, what? I was excited. I love PT with this couple of ladies that work with me. All right, here we go. Squirrels. This indictment is the product of months of illegal, right, and unethical behavior by the government officials. And then again, we've got this federal agency possibility down here. So if this brazen, continuous disregard for the law and the Constitution is not outrageous government conduct, nothing is. Yeah, I think that's a fair point. When you're trying to define that. Oh, good, Thomas. Oh, good. 867. Yeah, PT. It's great. It's just, I'm so thankful to be able to have that available where I'm at. All right, here's our background. Let's dive in here. Yeah, you can. It's hard for people to hide their bias right now because it's like their filter was broken when he took office the first time, and then they just switched what they were yelling about, and now they've switched back again. So it's kind of hard. Yeah, so gently. Yes, that's true. Background 8, transforming the FHFA into a political weapon. In March of 2025, William Pulte began his tenure as FHFA director and quickly transformed the little-known agency into a weapon to be brandished against Mr. Orange's political enemies. Yikes. None of that sounds all right. As FHFA director, Pulte is tasked with regulating the Federal National Mortgage Association, known as Fannie Mae, the Federal House Loan Mortgage Corporation, known as Freddie Mac, and the Federal Home Loan Banking System. All right, and then we got footnote 2 here, where she's just citing where that information comes from. VC, I agree. Although Fannie Mae and Freddie Mac remain private corporate entities since the 2008 financial crisis, the FHFA has served as their conservator. And then the citation is here. Mere days after being sworn in on March 17th, Director Pulte fired 14 members from the boards of Fannie Mae and Freddie Mac and appointed himself chairman of both entities. Ooh, that's not good. That's not very good here. No justification was given for the firings. This deeply troubled consolidation of power violates federal law and the FHFA's own regulations. Federal law prohibits the FHFA director from holding any office, position, or employment in Fannie Mae and Freddie Mac. So, I mean, they're operating under illegal actions already. So here it says, according to FHFA's regulations, the chairperson of Fannie Mae and Freddie Mac boards must be independent of FHFA. As FHFA Director Pulte is the furthest thing from independent, a little zinger there. On April 14th, Director Pulte sent a criminal referral letter to U.S. Attorney General Pamela Bondi, alleging A.G. James falsified bank documents and property records to acquire government-backed assistance and loans in more favorable loan terms as related to properties in Brooklyn, New York, Queens, New York, and on Sterling Street in Norfolk, Virginia. And I do not ever say Norfolk correctly. Oh, it's a big deal. It's huge. It's a huge deal. There's so many layers to these cases. So just one day later, someone from the inside of the administration leaked Director Pulte's criminal referral letter to the New York Post. Whoops. Yep. After the issuance of the referral letter, according to the recently produced discovery, an expansive and fast-growing investigation into A.G. James's properties and related mortgages took off within FHFA and Fannie Mae. So they just targeted her. I mean, this dude got the job and was like, all right, let's look and see if there's records for any of the people we don't like. On April 17th, Fannie Mae requested the James loan file from mortgage servicer Mr. Cooper. On April 18th, FHFA Office of Inspector General sent a demand for document production to the Federal National Mortgage Association director, seeking access to records, reports, and documents concerning A.G. James's property. Also on April 18th, a Fannie Mae fraud investigator sent emails attaching social media posts by A.G. James's great niece, Nakia. Oh my gosh, that's gorgeous. Gorgeous name. Thompson. And on April 25th, mortgage servicer Mr. Cooper received a request to investigate potential misrepresentation of occupancy concerning the Perrone. I guess it's probably going to say property, right? Property, look at that. All right. And A.G. James. Discovery revealed that the investigation continued unabated within FHFA and Fannie Mae throughout May, June, July, and August. I mean, can you imagine? Let's just take a minute here. Can you imagine, like, somebody just going in there and being like, okay, I'm in charge of all of these different important tasks. But first, I've got a list of people's names. Let's go comb through the files and see if, they didn't print their name, that they used cursive instead. Like, this is just, like, gross how this kind of extortion, blackmail stuff is going down. And the level it's going down, again, leads me to believe that that's one of the things that Orange has. The other thing with Mr. Orange is, if any of you were with me when we were going through the testimony of the National Enquirer guy during the Stormy Daniels case, right? And there was an issue because Mr. Orange wanted all of these, not really even records, but like notes and stuff that he had with that dude. And he was super pissed because the dude's like, no, we're going to keep that. And, Mr. Orange is like, oh, there might be something in there that's incriminating. So I think that's a very interesting take on things. I think he definitely's got some blackmail material going. So don't do stuff, people, that can lead to blackmail, all right? Come on, come on. Despite the fact that the criminal referral purports to be based on media reports, no credible media reports remotely related to the allegations predate the referral. The origin of the exhibits to the referral are equally suspect. The FHFA does not house individual mortgage documents in its own system, but Fannie Mae does. Many of the exhibits referenced in the referral were available from a single source, which also contains the only, quote, reporting, end quote, on the allegations that predate the referral letter. The blog of a right-wing investigator, quotes, Sam Anter, all right, who has claimed credit for providing Director Pulte with the facts necessary for the criminal referral. Oh, okay. Accordingly, in crafting the criminal referral letter and the attached exhibits, Director Pulte either one, relied exclusively on a single fringe blogger's evidence that A.G. James committed fraud. That's the other thing too, is they just think it's so true. And I remember also when Giuliani was asked about that, when he was asked certain kinds of questions, he would just like give that information out just freely. Like, well, yeah, of course we did that because we want to do that. It's like, that's not right. They just heard it from one thing. I think one direct quote was, and I think he might have been Arizona, I can't remember, but he said during his recording, I'm trying to remember exactly where it was, a deposition. I think it was a deposition. Hold on, my story's not making sense because I can't remember it. Just a minute. It's coming back. Nope, I forgot it. All right, Giuliani's story later, everybody. I'll have to be later. All right, relied exclusively on a single fringe blogger's evidence. Oh, yes, I remember now. Okay. So Giuliani basically said part of some of the Ellie cases, right? Like the 85 cases that were filed saying that the Ellie was not a proper. And one of the reasons was because people going and stealing stuff out of the boxes and like moving them to different places, whatever it was. And so the person asked him, he's like, well, Giuliani, you realize that's just an old, like, what's it, like a wives' tale, an old wives' tale? Like that story's been going around for a long time. It was never actually true. And he answered, he's like, well, yeah, I know. It's an urban legend, but it started in the 70s, and he was like trying to justify using an urban legend situation as today's proof for improper ballot counting. That was a long journey. I thank you for staying with me. Anywho, number 2, took it upon herself to purchase these documents from various county clerk offices, or 3, unlawfully accessed A.G. James's loan files from Fannie Mae's database. Whoa, all 3 of those aren't good here. To prove there was coordination, that may be a piece of it. That could very well be a piece of it, for sure. Any one of these 3 most likely possibilities constitutes outrageous government conduct by the FHFA director. Fannie Mae ethics and investigations groups were so concerned that Director Pulte may have improperly and illegally accessed mortgage documents that they launched a probe into how he obtained A.G. James's mortgage documents. Well, they're going after him. According to reporting, Fannie Mae's Ethics and Investigation Group had received internal complaints alleging senior officials had improperly directed staff to access the mortgage documents of James and others. And investigators have been probing to find out who had made the orders, whether Pulte had the authority to ask the documents, to see the documents, or whether or not they had followed proper procedure. Yeah, intent on covering his tracks instead of allowing the internal investigation to continue. Director Pulte fired about a dozen members of the Ethics and Investigations Unit, because that's what they do. That's what they do. If you say something, you're going to get fired. So, that's how that works. According to reporting, the internal complaint alleging Director Pulte improperly obtained A.G. James's mortgage records was sent to prosecutors in the U.S. Attorney's Office in Norfolk by former FHFA Acting Inspector General Joe Allen, who believed the information he turned over was constitutionally required and or potentially relevant in discovery. For doing so, the acting inspector general was fired from the agency by Director Pulte, presumably because the information could be material to A.G. James's defense. This is huge. I mean, this is huge. If you've got any kind of exculpatory evidence, well, really are in exculpable, insculpable. You got to show it to the defendant, man. I mean, you just got to do that. That's the basic 101 when it comes to criminal cases. After making the referral to the DOJ, Pulte continued to pursue his own investigation, even when employees of Fannie Mae themselves believed there was insufficient evidence of wrongdoing. On June 13th, Sean Soward, here, a director... Right, knew about it. That's funny. All right, okay. Told Jennifer Horn, Fannie Mae vice president, the LJ case is certainly not clear and convincing evidence of fraud. That's another evidentiary standard here. Clear and convincing evidence in order to go forward in your case. Miss Horn responds, director asking how we know that the niece has lived there since 2020, clearly demonstrating Director Pulte's intimate and direct involvement in the investigation. Oh, yep, there it is, right there. If they have I would say outrageously wacky. Right. So then we've got more outrageous conduct here from Ed Martin, an outrageous conduct set out here. I'm going to just catch the ends of that so we got a lot of pages here, so hold on. Where's the end? All right, we'll go backwards then. Backing it up. All right, there's no conceivable legitimate reason for Mr. Martin to stalk A.G. James's home. After telling neighbors that day he was just happy to be on a block looking at houses. Just looking at houses, interesting houses. He told Fox News just the opposite 2 days later. I'm a prosecutor. I wanted to lay eyes on it. I wanted to see the property. DOJ rules and policies, as well as rules of professional conduct, squarely address prosecutors seeking to harass or even speak with a represented person, such as A.G. James, or use media to announce investigations. Likewise, the local criminal rules of this district dictate that with respect to grand jury proceedings, thanks, Aaron. Thank you so much. I appreciate you. Or pending criminal investigations, a lawyer participating in or associated with the investigation shall refrain from making any extrajudicial statements which a reasonable person would expect to be disseminated by any means of public communication that goes beyond the public record or that is not necessary to inform the public that the investigation is underway. All right, and then to describe the general scope of the investigation or otherwise to aid in the investigation. Here's our local criminal rule. Local Rule 57.1 also prohibits prosecutors from releasing any extrajudicial statements or interview relating to the trial or the parties or issues in the trial, if such a statement will interfere with a fair trial. Additionally, the District Court of Columbia Bar, of which Mr. Martin is a member, has clear rules of professional conduct, including Rule 3.8, which outlines special responsibilities of prosecutors, prohibiting the kinds of important and prejudicial actions in which he deliberately engaged with in respect to A.G. James's case. Mr. Martin deliberately flouted those rules to create unfavorable pre-indictment publicity. So he's definitely running around. All right, so Ed Martin and his bad behavior, because she's saying this needs to be dismissed because of outrageous behavior. So now we've got Ed Martin's outrageous actions. Next, we've got Lindsay Halligan, whose only credential is loyalty. So then they're going to go through what road did she take as well. I need a summary. Yes. So let's take a look and see what they've got here. Now, this is where we're going to get really into whether or not she has violated her ethics. Spoiler, yes. All right, the government engaged in a series of illegal and extraordinary maneuvers to install Lindsay Halligan as the purported U.S. attorney for the Eastern District of Virginia, when no one else would bring the indictment against A.G. James. After the Senate confirmed U.S. Attorney for the Eastern District of Virginia resigned in January of 2025, A.G. Bondi appointed Eric Seibert as interim U.S. Attorney pursuant to 28 U.S. Code Section 546. On May 6th, Mr. Orange submitted Mr. Seibert's nomination to the Senate. When Mr. Seibert's interim appointment expired on May 21st, the district court judges of the Eastern District of Virginia exercised their appointment authority under Section 546D and unanimously selected Mr. Seibert as the interim U.S. Attorney. Reports indicate Mr. Seibert and other prosecutors within the U.S. Attorney's Office were unable to find any incriminating evidence of mortgage. Oh, I got the puzzle, everybody. Okay, hold on. I got the puzzle. Fingers crossed. Here we go. Oh, it's so stressful. We're going to get it. Let's see. Oh, we got it. Yay! Yay for us. I need to practice, I think, the puzzle. And I'm not on the lights. So it could just be muscle memory. That'd be great. All right. Backing it up here. Right. All right. So reports indicate that Mr. Seibert and other prosecutors within the U.S. Attorney's Office were unable to find incriminating evidence of mortgage fraud against A.G. James. But Director Pulte was not willing to let the lack of evidence or the judgment of career prosecutors stand in the way of his ambitions to please Mr. Orange. In September of 2025, Director Pulte reportedly lobbied the president to fire Mr. Seibert in order to resurrect the failed case against A.G. James. Woo, that's getting into the malicious intent element. Reports indicate that in the Oval Office dining room, Director Pulte told the president that Mr. Seibert had been picked for the U.S. attorney position by Democrats and was blocking charges against James. So this was the part of the tweet when they said, we almost had a Democrat in as an attorney. President Orange was persuaded by Director Pulte and ordered aides to remove Mr. Seibert. On September 19th, Orange told reporters in the Oval Office that he wanted Seibert out. Orange stated that he believed A.G. James was very guilty of something. That's not how the system works. I think you've done something, so let's go dig for it. Like, no. An assessment that reportedly contradicted the views of both Mr. Seibert and Deputy Attorney General Todd Blanche. Blanche is involved. All right. On September 20th of 2025, Orange posted a statement on social media urging A.G. Bondi to appoint Lindsay Halligan and prosecute A.G. James, as well as former FBI Director Comey and Senator Adam Schiff. Right. The post read, Pam, I've reviewed over 30 statements and posts saying that essentially the same old story as last time. All talk, no action. Nothing's being done. What about Comey, Adam Shifty Schiff? Leticia, they're all guilty as hell, but nothing's going to be done. Then we almost put a Democrat-supported U.S. attorney in Virginia with a really bad Republican past, a woke rhino who was never going to do his job. That's why two of the worst Dem senators pushed him so hard. He even lied to the media and said he quit and that we had no case. No, I fired him, and there is a great case. And many lawyers and legal pundits say so. Lindsay Halligan's a really good lawyer and likes you a lot. We can't delay any longer. It's unaliving our reputation and credibility. They impeached me twice and indicted me 5 times over nothing. Justice must be served. So that was the second person. And then C, ignoring the evidence and removing resistance here for an indictment is returned. Fast forwarding through here as well, everyone. And taking a look here at her argument. So we've got the indictment against A.G. James should be dismissed because prosecution arises from outrageous government conduct, which is what she's been setting out and putting into place here. So then now what she's going to do is take that information and she's going to use the statutes in order to make her argument. All right, well, let's fast forward a little bit. This court should exercise its supervisory powers to dismiss the indictment. So that's a side note. Usually we don't really ask the court to go outside of whatever it is they're doing. But there are some situations where the court has the power to put their foot down, right? So in a supervisory power, they could dismiss it, just like they can bump an attorney off of a case or make an attorney stay on a case. They do have discretion in their own house, which is their courtroom. They have a lot of discretion regarding that, and so they're tapping into that. And they're saying, there may be other things going on here, but it is one of your house rules that if she's out of line, then we can toss the indictment. So they're asking the judge to do that here. And here. And then in the alternative, so if they don't win that one, Attorney General James is entitled to discovery, further demonstrates the illegal basis for the charges against her. So one more hit there. And then we come over here and we've got, accordingly, in addition to the communication listed above, A.G. James specifically requests the government be ordered to produce. So she's actually putting her discovery request in her motion to dismiss, which that's interesting. Why not? Why not do that? Any internal complaints filed against Director Pulte related to A.G. James. All documents bearing the this Bates stamp, including these here. So they're looking for more information on this specific piece. In conclusion, A.G. James respectfully requests that the court issue an order dismissing the indictment with prejudice for outrageous government conduct, or, in the alternative, issue an order granting discovery concerning the government's outrageous government conduct. How many governments we got there? Concerning the government's outrageous government contact and the evidentiary hearing regarding the same. So there we go. There we go, everybody. I think so too. So what's great, though, is you have an incredibly well-educated, very powerful group of lawyers helping, and we like to see that. We really do like to see that. I thought I had that order, but this is actually the DC order. Hold on here a second. I must have gotten my orders mixed up. Yeah, was this it? Nope, that's Comey. What about this one? Nope, Comey again. And then, Nope. Oh my gosh. Hold on here. Nope. I guess it's gotten, I'm going to have to go chase down Atticus. But her case right now is just, again, slowly going through and trying to get her docket sorted at this point. But Comey also has a huge motion to dismiss claim. Now, she's in here and she's describing the inappropriate conduct that was going on, or the outrageous conduct uh, that was happening. And then he's going more from the vindictive prosecution situation. So both cases are running. I know, right, Carol? James' indictment will be dismissed. I think, all right, here's my personal opinion. I think both cases will be dismissed. I think there was some jury shenanigans going on, and you can't shenanigan with a grand jury. If you shenanigan with a trial jury, that's one thing we can kind of work around that. But if you're messing around with that grand jury, I mean, that's bad business. So I think his case will get tossed, and I think hers just the evidence isn't there. There's no probable cause even, and so she's ordering discovery. She's asking for discovery because she's like, "What are you even talking about? What are you even talking about? Because what information do you have that's different than what I have that shows there's some kind of violation?" Because there isn't a violation, and so this could go forward with more discovery. But it's going to be like pulling teeth because the government doesn't want to give any information away. That would be annoying as heck. Or it will go through the dismissal process. So I think it's likely both will be dismissed. In my humble opinion, based off of my own career as an attorney. But you just never know anymore. I mean, our judges right now, like even, oh my gosh, our judges right now are really trying to feel out what's really going on here and stay within the confines of the law, but also not get targeted. It's like, keep your head down. Yep. I agree, Navy vet. I agree. Yeah, and yeah, exactly. I agree. There's yeah, we've got some trouble in River City, everybody. We got some trouble here for sure. This person right here, that's the trouble. That's the trouble right here. But we'll be continuing to go forward. And she's basically gonna be swimming up. Wait, that's not the right one, right? Upstream against the current. I'm sorry. I'm sorry, everybody. I've had only half of the amount of caffeine I normally have at this point. She's going to have a tough road ahead of her. She was already on a tough road, but she made it even more difficult for herself by not, figuring out the process she was supposed to go through. Because if you're an attorney, that's what you do. They're like, here, take care of this. You're like, I'm not competent. Or you make yourself competent, right? Because you're in charge of that. You can make yourself competent enough to handle cases, even if you've never handled them before. But this was not it. There you go, Thomas. Right. The Greek. She's going to be the next disbarred. It's going to take some time, but I think she's definitely going to be in the queue. How do you get the court sketches? So these are just available online. I haven't put the artist's name on here because I was rushing around today, but there are several artists that do them, and you can just ask, when you're on the Googles, you go in and you're like courtroom sketches. It'll give you a list, and some are just, you want to catch the ones that do it a lot, and just go in and take a look at it. But they're all publicly made available. You just want to watch copyright issues. This is an educational situation, and so that's why we don't have any problems here. But oh, thanks, Oilers fan. Oh, thanks. That's so sweet of you to say. How do they work? Are they paid by the court? I'm not sure if they're paid by the court. I would say probably no. I do not think they get paid for that, because the court's like, if you all want to know what's happening, that's your problem. It's not our problem. What they have is probably like a business, an art kind of business. And then when they do something like this, they sell it. So they sell it to the legacy media, and they're like, you can use the picture, and then that's how they get their cash for this. And then also they can sell artwork as well. Many of them have some really lovely websites where you can go in and look at all the different trials, like 15 years worth of trials, and courtroom sketches and all kinds of stuff. So it's very cool. The news outlets, right. Yep. not doing anyone right. Well, right. And there's good ones and there's bad ones. Luckily, I've seen mostly the good ones. But of course, there's, some people, several sketches. Yes, yes. And I think there were three specific artists for the criminal case against Orange. There were three, and their styles were different. So you could kind of tell who was where and where they were in the courtroom, even based off of their perspective. Right. That's funny. Oh, yes. So that's how that works with the courtroom sketches. We're thankful because, of course, again, we're in these kinds of cases that are this huge at this level. There no communicados going on there. A few people for a PD trial that were, well, yeah, and I'm not even looked back at that, Carol. I tell you, I'm still, again, as I tell everybody, I tell you all day. I'm really still in incomprehension or PTSD moment. I'm traumatized with the verdict. So I've not even looked back. I need to. Right, as per Taco. We should start using that as a sign off, as per what Mr. Orange says. Sorry. As per Taco's request. Taco. Oh my gosh. Yeah, it's a lot. It's a lot. It's a lot. Relevant, but do they have to register or just go with paper and pencils? Excuse me. Every courtroom has its own set of rules, honestly. They may be exactly the same, but each one has its own set of rules. So whoever house it is, you got to pull those rules up. So the judge will set out what he finds, well, because it's a dude here. He or she or them or they, whichever, they're the ones in charge of the courtroom. So if the rules say you can come in, get your seat early and come in, that's fine. But I don't think there's any seats actually reserved for the sketches. What I've seen is that they just wait and go super early and get a chair. They're like, all right, this is my spot. And then that's how we go forward. Oh, I know. Yep. Oh, yeah, I agree. Yay. Hi, Deli Kelly. Welcome back. Judge looks like Reagan. After a while, and this is going to sound terrible, and I'm like, all right, whatever. But after a while, I have a hard time with, dudes that look like this because they all look the same to me. Like this guy over here, he's got glasses, but this could be this guy or this guy. We don't know. That he just doesn't have the glasses. There's some kind of regular, dress code. I feel like for certain haircuts have to be like this if you're gonna wear a blue suit, right? Or you can only use this color of a tie. It seems like they're coordinated. Yeah. I mean, again, yeah, fill in the blank. That was one thing about Emile Bove was because he didn't have any hair. We could at least figure out which one could be him. And then also because his other Sour, I think it was, is huge, broad, gorilla shoulders. And so it's his shoulders tick up this much of the page. This was just his shoulders here. So you kind of figure it out that way. But with these, nope, they just kind of look a little different. Yep. Right. Oh my goodness. Yeah. So for tonight, everybody, this will be my conclusion of Miss James here, A.G. James. Tonight, I have the order that came out yesterday from the District of Columbia, right? So we've got National Guard situations shaking and moving here, and a pretty good decision that was. And when I say good, I mean I don't have to get my red pen out, all right? That came out as well. So my hope, as long as I'm feeling okay, my hope is to be able to do this one later today and then call me tomorrow. All right. No, not yet. 867-5309. Sorry. No word from SCOTUS as of this moment. I would tell you though, SCOTUS blog has like really up to date moments. Like if you're getting worried, they're almost always like the first one in line for stuff like that. Of course, my pleasure, my pleasure. You bet, Carol. You bet. I appreciate all of you coming by today and hanging out with me and my scattered brain and my sweater sleeves. I appreciate all of you. Thank you for the gifts, everyone. But, mostly thank you for coming by. I really do appreciate it. Hopefully this made a little bit of sense. And so now you know what's going on with A.G. James's case. And I will be tracking this one along with Comey's case because they're just enormous. They're just large, crazy cases. So have a good rest of your day, everybody. And I will try very, very hard to come on back tonight. So see you all soon.